Welcome back, and hope you are having a nice morning. We are going to proceed with business and immigration law updates. This will be presented here by Mr. Ramesh Khurana, attorney and counselor at law. Attorney Khurana is the chief attorney at the Khurana Law Firm, located in Gaithersburg, Maryland. The moderator here on this screen is Attorney Kenneth Haber from Boyd's, Maryland. This morning, Attorney Haber questions Attorney Khurana on strategies of an H-1B employee to avoid the catastrophic situation of outgoing of status. Let's see.
Welcome. My name is Kenneth Haber. I'm a former Assistant United States Attorney and I'm a former Senior Attorney in the Office of Inspector General of the United States Department of Health and Human Services. In the studio today we have Ramesh Khurana, who's here to give us some information about immigration, and this is the Capitol Forum. Welcome, Ramesh.
Thank you. I appreciate it.
Ramesh has his office in Gaithersburg, Maryland, and he has a practice across the country, and we're right now ready to grill him about immigration law. You
Sure,
ready?
I like to be grilled.
Okay. Medium, rare, or what?
Very hard.
Very hard, okay. Can you give us some of the strategies involved in an H-1B employee, how he can avoid the catastrophic consequences of falling out of status?
Oh, sure. You know, I think the most catastrophic situation which I hear from my H-1B clients is employee is given a bad news that in 7 days he will lose his job. As the project is no longer available, now the question he would like to ask immigration lawyer is there any grace period for the H-1B employee?
Is there?
Is there any grace period?
Yes, is there?
No, unfortunately no.
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 What can he do?
Yeah, there is no automatic 10-day or other grace period for terminated employees holding H-1B status, unfortunately. You know, one thing is when people come at the port of entries and let us say that their H-1B visa will be expiring in 1 year, at that point of time they can ask the CBP officer to add 10 more days because they are issued one I-94. So 10 days can be added at the time of seeking admission, but those 10 days are not basically would be the grace period for the purpose of finding another employer and filing H-1B petition. That is just that you can stay in the United States in a valid status to wrap up and go. So,
but if you use those 10 days and can find another employer in 10 days, could you then have that employer file for you and keep staying?
Unfortunately, you can file it, but the best practice is to go out of the country and present yourself before the U.S. consulate and explain what had happened to you and then get a new H-1B visa and come back.
Otherwise you're out of status and it's more difficult.
Yeah, because during that 10-day grace period, basically you are not supposed to be applying. But another thing is we have done change of employer cases all the times when people lose their jobs and they go out of status, so-called. We have to ask for forgiveness of USCIS. We have to explain the circumstances, that he is a victim of the law and the circumstances. How do you know that you are going to get the bad news tomorrow and you will be out of job and you find yourself, you have probably already bought a home or you have leased your home for 3 years and you have already owned 2 cars or 3 cars, how you can leave this country and go home? Suddenly you cannot. So you ask for the forgiveness, and the good thing is that USCIS has a sound discretion to exercise. So you ask them to exercise the sound discretion and allow the change of employer, and I have succeeded in some cases even after 30 days or 40 days. But again, it is purely subject to the discretion of the adjudicating officer. There is no matter of right. But I have seen that sometimes people have overstayed for a longer period. So we file for the forgiveness. Although the forgiveness is not given, but the petition will be approved and they would say, let the person go out of the country and return on H-1B visa. That means he will have to go to the US Embassy or the US Consulate and he will have to get a new H-1B visa and come back.
Would
So there are ways.
Would the approval be preordained, so he just has to go and get the stamps, or does he have to go through the whole process at the embassy?
No, he has to go through the whole process at the embassy. Yes. Yeah.
That could be complicated, I'm sure.
Yeah, it's complicated. Like again, you know, another adjudication is being made at the U.S. Embassy. Again, you have to prove that this was a bona fide job offer because this is the second guess by the State Department. The petition was approved by USCIS, and now it's going to the U.S. Embassy, and Embassy wants to make sure that whatever declarations and submissions have been made in the petition, those are true. Yeah.
And he's going to be by himself. He's not going to have you there.
No, in fact, unfortunately, lawyers cannot be present along with the beneficiaries of H-1B petition at the time of interview, because embassies have decided not to allow lawyers to go, to allow them to go for the interviews, because they cannot handle so many people because of the security reason as well. Yeah.
Which is different than obviously when people are getting married or been married and they're applying as on
Even
a
in
spousal.
those cases, lawyers are not
They're not,
permitted.
they do permit the spouse though.
No, even now instructions are very clear that even spouses are not permitted.
Oh, really? 'Cause
yes. Again,
back
because
when
of
I got married 13 so years ago, they did.
yeah, because of the security reason, they are not permitting the spouses. They are clear instructions. When they send the interview letter, it's stated right there that your spouse is not permitted to come inside.
Wow.
They can't handle so many people. Yeah.
Wow. That's interesting. Times change.
Yeah.
If an employee expects that he'll be finding a job within a couple of months, is there any way he can continue staying in the United States?
Again, he is risking his status because he thinks that he can find a new job in a couple of months. As I said, the moment that person loses his job, technically he has gone out of status. And if he is able to find a job after a couple of months, so he will have to apply for change of employer. So if he has to apply for change of employer, he needs to be in good status. Again, if there is no other option, some people decide to do it anyways. Again, lawyer would ask for the forgiveness. Maybe USCIS forgives this gap.
What's an O visa?
You know, O visa is basically meant for those people who have extraordinary ability. So there are about 10 prongs, and if a person can satisfy those, at least the minimum required prongs, which are 3 out of 10, then that person can be granted an O visa. The good thing is that, let us say a person is holding a PhD degree and he has written several articles in trade journals or other newspapers, and he has made presentations among his peer and other organizations, and he has won certain awards, right? And there are people who are willing to write recommendation letters or opinions about that person. And these persons should also be experts in the particular field of endeavor. It's not that I know that you are an outstanding lawyer in Maryland, but if somebody approaches you to write a recommendation letter, I am pretty sure you will write an excellent letter. But the question is, you are an excellent lawyer, but you are not a scientist if the petition belongs to a scientist, right? It's a scientific field. So he needs to find some experts in the field of his or her endeavor, and only then those recommendation letter would carry some weight. So if it is that kind of situation, yes, if a person has lost his H-1B status, maybe he can change to O-1. That's an option available.
What about an EB-1? What's an EB-1?
EB-1 is again an extraordinary ability visa. Let us say there are certain scientists who have PhD degrees. Again, they have written some very authoritative articles, and they have won certain prizes, so they can apply for EB-1 category as well. Yeah, that's basically a green card. EB-1.
You get a green card with that one too.
Yeah. Yes.
That must mean that they're extraordinary that they're getting the green card.
Yeah. So this is called basically extraordinary ability.
Extraordinary, not just extraordinary.
Yeah,
but
not exceptional.
Not exceptional. Extraordinary. Extraordinary.
Yeah. Okay.
What's the procedure for applying for a tourist visa or H-4 based on a green card?
That's another option, Ken. Let us say that a person has lost his job. He is out of status. We did talk about the fact that there is no automatic grace period. But his spouse is also on H-1B status. If that is the kind of situation, then this person who has lost the job can immediately apply for H-4 visa. And that way this person can remain in valid status. But that person has to make sure that his spouse is keeping his status in good order, like he is getting paid and all that kind of stuff. And when he files that H-4 application, H-4 application will be approved for the period which would co-terminate with the approval granted to the principal. So that's the H-4 application, and that way this person who has lost this job and gone out of status can at least save his position for the time being. And I have seen many people doing like that, especially when husband and wife both are professionals and both of them are H-1Bs. One of them loses a job, then this person changes the status to H-4 and keep on trying to find a job. And whenever this person finds a new job, H-4 application may be pending. Sometimes H-4 application is not approved for several months, then it becomes a kind of bridge. It provides a status. So based on that bridge, you again switch over to a new H-1B status whenever this person gets a job. So this is used quite often.
Can the tourist visa be used under these circumstances as well?
Yeah, tourist visa, that's little bit tricky because let's say that you do not have any option and you get a notice from your employer that you will be losing your job in 15 days. At this point of time, let's say that your intent is very important. Like you really want to go around the country because earlier you were going to school and then switched over to H-1B visa. You didn't have any time to see the United States. Now you say that I have got some time because I have lost my job. I want to go and take a tour of the United States. I want to go to Seattle, right, while you are sitting in Maryland, and I want to go to California. So if you have real good plans and you have money to support yourself, you have to prove that let's say the $10,000, $15,000 they are lying in your accounts and you can financially support yourself, because this factor is also equally important, because they want to make sure you do not become a charge on the state.
Right.
If you do not have money, so you are going to be a problem down the line for this country. So if you have proven this fact that you have resources to support you and this is your intent, so you can apply for a tourist visa which is called basically B1, B2, and you can apply for 6 months. Now what happens that this was really intended so by you that you want to go around and see the places. After a couple of months you see another job offer. Now this job offer you accept it and your employer files a petition which will be for change of status from B1, B2 to H1B, and if you are left with some period for H1B, depending upon maximum you get 6 years, or green card process has started, you get several more years. So then at that point of time your employer will apply for change of status from B1, B2 to H1B. So that tool is also used sometime by most of the employees.
It
Yes,
sounds like a logical one to use because
Yes,
it's
yes.
not complex as long as you got the money. in the
that's
bank.
true, that's true. But again, you have to make a good case,
You buy it.
because if it is not approved, then it becomes a bridge, and if the underlying petition is not approved, whatever petition is filed later on, that will be denied too.
Well, I see that that it's about that time to wrap up.
Yeah.
Is there any specific suggestions on this general area of topic that you'd like our viewing audience to keep in mind that you might share with them at this point?
Sure. I would like to remind the H-1B beneficiaries especially, if you are likely to lose your job, please make sure that you take some swift action, because you start incurring, even in certain cases, unlawful presence. And if you have incurred your unlawful presence of more than 6 months, you may be barred for 3 years if it is less than 1 year. And if your unlawful presence is more than 1 year, then you are barred for 10 years. Yeah.
Well, thank you very much for coming on in and sharing this information with
Thank
the
you very
viewing
much,
audience.
Ken.
Thank
I
you.
enjoyed this session with you.
I did too with
Thank
you.
you.
Thank you.